Okay, the next case to come before the court is State of Ohio v. James Thomas. Each party will have up to 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I'll be keeping track of the time. The arguments are being recorded, so please stay behind the podium and keep your voices up. Please introduce yourselves to the court. You should not use the names of victims or minors or children. You can use initials or generic terms. The judges have read your briefs. We're ready to proceed when you are. And Attorney Brumke, I would just ask, do you want to reserve time for rebuttal?
I will reserve 5 minutes of my time.
Very well, then we are ready when you are.
Great. Giovanna Brumke again on behalf of Mr. James Thomas. Mr. Thomas was charged in this case with one count as a misdemeanor of the 3rd degree of sexual imposition. It's a fun set of facts. Every time we're dealing with overwhelmed college students, I think it is. But in this case, Mr. Otero and the college student, who is LH, initials LH, were walking down the road.
Mr. Thomas.
Mr. Thomas. Did I say? I'm sorry.
Yes.
Mr. Thomas and the student were walking down the road. He was asking for money. The student had said she didn't have any money, but that she was willing to take him to the local ATM at Huntington Bank in Oberlin. They walked together to the Huntington Bank, and at that bank, and there's some testimony with regards to this, that the ATM is sort of in its own room. And so the two of them walk into the room together, and she enters her PIN and actually asks him, to step back. I think her testimony was she was a little bit nervous that he was, going to steal her PIN number or whatever it may be, and he does comply with that. He steps back, and she takes out money, actually pays additional money for an out-of-network ATM fee, and hands him the money. He is grateful for receiving the money and gives her a hug. There is a series of what I would describe as 3 consensual hugs that happen here. At the trial, it was a jury trial, he was found guilty of this one count. And prior to the start of the trial, there was a motion in limine filed to exclude regarding this evidence the state wanted to introduce and the defense wanted to exclude regarding other incidents that day. So, of course, there's no charges related to the money in this case. There's really no dispute. It appears that money was voluntarily given, and there was no theft charges or deception, anything of that nature. The charge revolves around this sexual imposition because of the hugs, and Mr. Thomas has asserted that that these were consensual, friendly hugs, and the student has asserted that these were sexual in nature. So
that was also on video, though, correct?
There was a video, correct? ATM video, obviously. The ATMs have videos. But the main key issue came down to whether these hugs were for sexual motivation. So the motion in limine was specific as to prior incidences. One, in the state got up and argued at the opening these incidences. Although the court had reserved its ruling on the motion in limine about introducing this evidence. So our first assignment of error is prosecutorial misconduct in introducing this information that prejudiced Mr. Thomas, and this information specifically went to that sexual motivation. There was, and I had cited in my brief, the paragraph from the transcript that talks about what was said in the opening statement. But in short, it was talking about the Doobie's smoke shop manager who was going to testify that Mr. Thomas had come into the Doobie's smoke shop and had asked, according to the woman, asked her to have sex with him. And also a woman from the Hope Collection, an employee there, who he asked if she, according to her, this was what the state was seeking to introduce, that asked her if she was single and shook her hand for a very long period of time. and that the state repeatedly referred to this conduct as creepy. And again, that specifically goes to the sexual motivation. So the court actually made the ruling, but on the motion in limine to allow for it, but it did not, no witnesses were ever presented with regards to these.
The ruling was after the opening or before?
After, so it was argued before, but the state reserved its ruling on it. And that's sort of an important point, is that even though there wasn't a ruling on whether this would come in, this information was introduced. And that's what we're, alleging is the misconduct, because even though those witnesses were never presented, that information was presented to the jury, and we know.
So one witness was presented and got nervous and couldn't testify, that I understand from the record what happened?
Yes, you are correct, but never as to this incident that was described in opening about any of, I don't think there was actually much testimony at all from that witness.
At any point, did defense counsel move for a mistrial regarding those statements?
I can't say, not to my recollection, but I can't say for certain that he did not. There was quite a bit of argument on it, a lengthy argument back and forth on this issue. So again, we would submit that introducing that information without, number one, a ruling from the court, or number two, the ability to enter that to evidence, and that specifically goes to this sexual motivation. That was literally all that needed.
Counsel, did the court indicate to the jury how they should treat the opening statement?
I don't know specifically in this case. I will submit to you that that's probably a common, indication to the jury that those are not testimony. But I think that, what we know of jurors is that they're lay people, they're not attorneys, and that they do consider those arguments. So that is very prejudicial to introduce that he's, asking for sex from other women on that same day, when this is not necessarily evidence that has been ruled to come in.
The prosecutor at least cites some cases that says there has to be some bad faith on the part of the prosecutor when they make the statement during opening. Do you agree that there had to be some showing of bad faith on the prosecutor's behalf when they made these statements? Look, I think my case is going to be X in opening.
Well, I think the bad faith comes down to the fact that the court hadn't ruled on it,
It's
so.
not the prosecutor's fault.
What was that?
It's not the prosecutor's fault or the defense counsel's fault. The court didn't rule.
Well, the court didn't rule, but without that ruling, say the court would have ruled that that was subsequently not permitted to come in, and then that, and then that evidence does come in, that has to be a consideration.
It's not evidence that came in, it's just prosecutor's statement.
Prosecutor statements, but it's information that that jurors would have received that would have prejudiced Mr. Thomas.
So couldn't the defense on closing say, hey, she gave you an outline of her case, and these witnesses, they said, we're gonna be here, aren't, and.
He could have, and to draw further attention to that, again, I don't know what it would have been the best decision, but, and I agree, I'm not arguing that opening statements are testimony, but regardless, those statements are prejudicial to Mr. Thomas, because there was, potentially the court could have ruled that they didn't come in, and second, there was no ability to get them in through these witnesses apparently. So, that information was only submitted through the state.
And counsel, so is it your argument that that was determinative of the jury's decision?
I think that the main issue in this case, and I argued in my other two assignments, is the sexual motivation in this. So it's no surprise that Mr. Thomas has repeatedly asserted that these were friendly hugs and gratification, in to show his to show his appreciation, I guess I should say.
I think the issue here seems to me from the victim concern, using that term, I guess. It's not that they were hugged, but during the hug, he tried to grab her behind, which is not necessarily a consensual hug, and she didn't consent to that part of the contact.
So, I think it's important to note in that regard that this student didn't come forward until she really felt like she met with another student, and she said, well, I really felt tricked on this money. And, so it wasn't a concern, and I think that that's important. Her, state at the time, she wasn't concerned about these hugs. She was concerned that she got, taken on giving him money. And that's, what led her to report to the police, but ultimately there was no charges in regards to the money. It was these hugs. So I think that her mindset on this day, of whether those were sexual in nature or not, I mean, you can give somebody a hug, touch their butt and it not be for sexual gratification. And I would submit to you that that's what she had thought until the point where she felt like she was tricked on this money issue.
And counsel, I should let you know you're at your 5 minutes.
Okay, I will, subsequently, we touched a little bit on my arguments on the sufficiency and the manifest weight, and again, all of that kind of goes to the sexual motivation and whether these hugs were consensual or sexually motivated. But again, I would submit that, it wasn't until she felt tricked on the money that she came forward subsequently on this issue, and it was even her intention, her assertion, at the time, her actions show she wasn't concerned about these hugs. She was more concerned about.
And counsel, on that point, then the victim, in this case, she testified?
She did.
And she was subject to cross-examination on this point?
Correct. She was.
Okay, and there was a video?
There was a
That was
video.
played for the jury?
Correct, there's an ATM video that's in
Okay.
evidence, yes.
Thank you very much. You will have 4 minutes on rebuttal.
Thank you.
And 3 seconds.
Good morning, may it please the court, my name is Farah Ameka. I'm the prosecutor for the city of Oberlin, and I'm here on behalf of the state of Ohio. And I'm asking that the court affirm the conviction in this case of sexual imposition against Mr. Thomas. The reason why I'm asking is because on May 17, 2022, Mr. Thomas did have sexual contact with LH, which was offensive to her, when he rubbed her buttocks on 3 different occasions during an extended encounter with her in the downtown area of Oberlin. As to the challenges and issues raised by the defendant in his brief, I submit to you that there was no prosecutorial misconduct in this matter. Before I get into that, I do want to kind of talk about the facts just briefly. One, I will submit to the court that this is not a fun set of facts. I think it is perhaps an interesting case, but from the perspective of the victim, it was a difficult situation that she was trying to figure out how to navigate. She has the additional set of circumstances that she has Asperger's, which impacts her ability to read social cues. That's the kind of lay, simple definition of that. During her encounter with the defendant, she did not offer up to go to the ATM with him to get the $20. She did decide to give him the $20 when he asked her if she had a debit card and suggested if there was an ATM in the area. That's how they ended up at the bank, which was not too far from where she first encountered him. And then also, just to clarify, the video evidence that was presented was not just from the ATM. The ATM had a video, and there were also other surveillance cameras within the room in which the ATM was held. There were 4 different views that you could actually see of these encounters between the victim and Mr. Thomas. Now, going back to my argument as far as the prosecutorial misconduct accusation or allegation, I submit there was no misconduct. As the court has already kind of presented in its questions, one, prosecutors and defense counsel are given great latitude in making their opening statements. Opening statements are just a roadmap to try to give the jury some orientation around what evidence the parties suspect is going to come in, or that they're going to attempt to try to bring into evidence. The question about whether or not those statements were made in bad faith, it's important to note that the defendant was 2 hours late for trial on that day. Had the trial started on time, it is likely that the evidence would have been able to come in for the one particular witness who worked at Doopie's Smoke Shop. Because the trial started late, the testimony of witnesses beyond the victim did not actually happen until the next day. It ended up running into a scheduling conflict for that particular witness, and she was not able to appear. The prosecutor is not gonna know that in the moment that they're making their opening statements the day before. And so those statements were not made in the opening in bad faith. It was truly the intention of the prosecutor to present that evidence. As for the witness from the Hope Collection, she got nervous on the stand and was not able to testify to what happened on the date in question. And got confused around that and was not offered, no other testimony was offered through her. So because the actual evidence did not come in, there really is not a prejudice to the defendant. Beyond that, as the court also has pointed out, there was significant other evidence upon which the jury based its conviction. The jury actually got to see itself and view the encounters between LH and the defendant. Got to see the nature and the
Going
context.
back to misconduct before we leave that.
Yes.
Was it requested, or was there any other instruction to the jury about not considering opening statements as evidence?
Well, so before opening statements were made, the judge did give a very specific instruction to them that opening statements are not evidence, they're not to be considered evidence, and that the parties are basically just providing a roadmap. Then, after the close of all the evidence, the judge gave another instruction on the fact, well, actually before closing, gave another instruction that closing is not evidence as well. And then they had sent back to them, read to them before it was sent back to them, the instruction that openings and closings are not evidence. And the judge kind of discussed too, before the openings that, you know, the parties present to you what evidence they intend to bring into, before them and have come into the record. It doesn't necessarily mean that it's actually gonna make it into the record. So the jury was definitely, on more than one occasion, instructed as to the fact that openings and closings are not evidence, and as the law states, jurors are presumed to follow the instructions that are given to them. And they even have it in writing with them in deliberations.
I have a question, just on sentencing. I didn't see anybody, there's a mandatory sex offender registration involved with this charge and conviction. Is he now a sex offender? Because I didn't see that as part of the statement of facts, or statement of the case, excuse me.
Right. What ended up happening is the defendant filed a motion with the court asking for essentially a stay on all of the conditions of the sentence.
I see.
Because of this appeal. So
So he's been sentenced,
he has not
or
been
it's
sentenced.
been stayed, or he has not been
Well,
sentenced yet?
He has been sentenced, and his sentence was stayed.
So he never was given any sex offender registration,
No.
even though that's required by law?
Right, no, there's no sex offender registration at this point in this case. It was stayed pending the outcome of the appeal. So based on the prosecutorial misconduct challenge, the other big point of that is, it has to be that but for, if you find that the statements that the prosecutor made during the opening statement were misconduct, you have to also find that but for those statements, the outcome would have been different. And that simply is not the case here. There's the video evidence, there's the testimony of the victim which contextualizes that video evidence, and that is what the jury, I submit to you, that is what the jury based their decision on there. Moving on to the sufficiency of the evidence argument, essentially the standard there is whether after viewing the evidence in the light most favorable to the prosecution, that the trier of fact was able to find that the state established each essential element beyond a reasonable doubt. I submit to you that the state did. Sexual imposition requires sexual contact with another, not the spouse of the offender, that is offensive to that other person, and that the defendant knew or was reckless in knowing that that contact would be offensive. Sexual contact includes erogenous zones. The buttocks is an erogenous zone. LH and Mr. Thomas are unknown to each other until they encounter each other on the street in downtown Oakland on that day. They had no other prior knowledge of each other. And then whether the contact was actually offensive to LH, well, one, she testified to the fact that it was. Her, although the defendant tries to kind of explain the scenario as she didn't hear about those contacts until later when she realized she was tricked, that's not true. That was not the nature of her testimony at all. throughout her entire testimony of her encounter with Mr. Thomas, she's explaining to you how she's noticing his size, how she's trying to figure out whether or not she can get away from him safely. She's concerned about him asking about what her relationship status is, and she's actually lying to him about her relationship status in order to protect herself. She's trying not to tell him where she's going. So she's painting a picture for you, even as she's trying to figure out through her encounter with him what's wrong about it. The fact that she is not comfortable with this interaction, and then when he goes to touching her buttocks on 3 separate occasions, she has a heightened response each time. And on the 3rd contact, where he touches her buttocks, she actually runs away from him and is very, very afraid. So the offensiveness of the contact is really not a question here. And then as the
Defendant asserts that her initial concern was the money issue and not the sexual contact issue. Is that shown by statements to police or anything, or where did that come from?
that really is not the case. The victim's testimony was that she wanted to help the defendant out, and so that's why she gave him the $20. And throughout her encounters with the police, her testimony on the stand at trial, she never really talked about wanting her money back. It wasn't that she did figure out the fact that he tricked her and saying he needed $20 for gas, and now he's still standing out there in downtown Oberlin. But she also realized he tricked her in trying to get her in a space where he could have this offensive contact, sexual contact with her during their encounter. So those were the 2 aspects of why she kind of said she was tricked. Not just because he took her money, and no, she did not ask for a theft charge, and no, there was not one that was charged here. The money was not the focal point. The focal point was the fact that he extended beyond what consent there was to the hug and touched her in a sexual way for his own gratification. And then the fact that there was sexual arousal or sexual gratification here can actually be seen from the video. There's a certain context and nature to the way that the defendant touches her buttocks on the 2 occasions that you can actually see it yourself. And the jury viewed that themselves from when it happened on that day and time. It was not just her testimony there. And then the fact that he's asking her questions about her relationship status, where she's going, on more than one occasion throughout this encounter. And then at one point, during the 3rd encounter, he's kind of getting in close with her, where she's afraid that he's actually coming in for a kiss. He's asking her to take her mask down. There's many different aspects of this encounter between the defendant and LH that suggest that he is doing this for his sexual gratification and his sexual arousal. And then the offensiveness of it also is that, again, these are strangers. So generally, you're not going to touch a person's buttocks if you've never met them before. And then as for the manifest, so I will submit to you that the state has met its burden of production as far as the sufficiency question is concerned. As far as the manifest weight of evidence, the defendant has to establish here that the evidence weighs heavily against the conviction. And so this court, in reviewing the record, weighing the evidence and the reasonable inferences, considering the credibility of the witnesses, determining any conflicts in evidence, and whether or not the trier of fact lost its way, is really going to have to stretch very, very far to find that the testimony of LH and the video themselves do not support the conviction here. They absolutely do. And then there's also the deference that's given to the trier of fact. The jury was there that day. They watched the video in the context of her testimony and were able to determine and did find that Mr. Thomas was guilty of sexual imposition. The defendant raised in his brief the fact that there was some slight inconsistencies in the victim's testimony. They were not significant enough to change any of the operative relevant facts here in this case. And again, from the conviction, you can presume that the jury found the victim to be credible and that the jury gave great weight to the video evidence. So there really is no basis upon which to reverse this conviction based on a manifest weight of the evidence challenge. And so I would ask that the court affirm the conviction here, and the reasons being that there was no prosecutorial misconduct, and any conduct on the part of the prosecutor did not change the outcome of the case. He is convicted based on the video and testimony of the witness. The witness was a credible witness. The video was a significant evidentiary factor in supporting the conviction, and neither of those things weighs heavily against the conviction here, so we ask that you affirm.
Thank you, counsel.
Thank you.
Ms. Bremke, you'll have just over 4 minutes.
Yes, I just want to briefly touch base on the question about him being sentenced, because I don't want there to be any issue about being a final appealable order. He was sentenced, he was ordered to register, it's page 7 of the sentencing entry, it's a long entry, as a tier 1 sex offender. He was also sentenced to 60 days and with 7 days credit and to be served immediately. But I will submit that simultaneously at the same time as he was sentenced, his counsel did file a motion to stay, which was granted. And there wasn't a question later about whether the sex offender registry was stayed. And I think pretty much all the parties agreed to the stay of that as well, that the law supported that. So he has been sentenced, he has been ordered to register, but that has been stayed pending this appeal. Again, assuming the facts that or the arguments I've already made, I would ask that you reverse this matter. Thank you.
Thank you, Ms. Bremke. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day that it is released, and it will also be posted on the Ohio Supreme Court website. Thank you again.